Hello, and welcome. For hundreds of thousands of people who have moved to the United Kingdom to work, to build a life, and to contribute to its society, a crucial promise has always illuminated their path. The route to permanent residency, known as Indefinite Leave to Remain, or ILR. For most, this has been a 5-year journey of dedication, a marathon of compliance and hope. But now, that promise hangs in the balance. The air in September of 2025 has been thick with anxiety. A proposal to radically overhaul the system, to double the qualifying period for ILR from 5 years to a staggering 10 years, has sent shockwaves through communities across the country. This has sparked a fierce debate about fairness, economic impact, and the very soul of Britain's relationship with its migrant population. The 8th of September, 2025, was marked on countless calendars as a day of reckoning. Many anticipated a final, binding decision, perhaps even from a court of law, that would settle the matter once and for all. But what truly happened on that day? And what does it mean for your future? The title of our video today mentions a final court decision. It is crucial to begin with a clarification. The pivotal event on the 8th of September was not a court ruling, but a parliamentary debate held in Westminster Hall. This is a vital distinction. A court decision can strike down a law, but this debate was a different instrument of power. It was the people's voice, channeled through their elected representatives, responding to a government proposal before it becomes law. It was a debate forced by the sheer will of the public. This story truly began in May of 2025, with the publication of a government policy document, a white paper titled Restoring Control over the Immigration System. Buried within its pages was a seismic proposal to increase the standard qualifying period for indefinite leave to remain from 5 years to 10. The government framed this under the concept of earned settlement, arguing that settlement is a privilege, not an automatic right, and a longer duration would ensure migrants have made a sustained contribution before being granted the security of permanent residence. This proposal landed like a bombshell. 4 skilled workers, from doctors and engineers to tech innovators, who had planned their lives, their mortgages, and their children's schooling around a 5-year timeline, it felt like a betrayal. It also cast a dark cloud over the unique promise made to British national, overseas, visa holders from Hong Kong, who had fled political uncertainty for the promised sanctuary of the UK. The response was immediate and overwhelming. 2 petitions on the UK Parliament's website became a digital rallying cry. The first, Keep the 5-year ILR pathway for existing skilled worker visa holders, argued passionately that applying this new rule retrospectively would be profoundly unfair. It declared that any changes should only apply to new applicants from a future date. The second, Keep 5-year ILR terms to Hong Kong British national, overseas, visas, urged the government to exempt this specific group from the proposed reforms, honoring the unique commitment made to them. Together, these petitions gathered more than 250,000 signatures, a testament to the profound anxiety and opposition to the plan. Under parliamentary rules, any petition surpassing 100,000 signatures must be considered for debate. The government could not ignore this outcry. And so, we arrive at the 8th of September. The debate was opened by Ben Goldsborough, a member of Parliament from the Petitions Committee. He, and others from all parties, gave voice to the people who had signed those petitions. They spoke of the human cost, of families uprooted and futures thrown into chaos. They highlighted the immense contributions these migrants were already making to the economy and the National Health Service. They argued that changing the rules of the game midway through is not just unfair, it is economically short-sighted, creating instability and making the UK a less attractive destination for the global talent it desperately needs. The debate was a powerful moment of democratic accountability, where the concerns of ordinary people were aired in the halls of power. So, what was the government's response? The responding minister acknowledged the significant public interest and the anxiety the proposals had caused. He stated that skilled workers must be treated with dignity while the policy is being shaped. However, for those hoping for an immediate reversal, the minister's words were a disappointment. The core message was that no immediate policy change would result from this debate. Petition debates are designed for discussion and to allow members of parliament to raise concerns, but they do not end in a binding vote that can alter government policy. The minister reiterated the government's stance, rooted in that May white paper. The concept of earned settlement remains their guiding principle. There were, however, 3 crucial takeaways from the government's response. First, And most importantly, the government is not backing down from its proposals at this stage. Second, the minister confirmed that these proposals will be subject to a formal consultation process in the future. He stated that the government welcomes the contributions from the petitions as part of this process, but crucially, no timetable for this consultation was given. And third, regarding the British national overseas visa holders, the minister reaffirmed the government's firm commitment to the Hong Kong community, though without making a concrete promise of exemption. This brings us back to the idea of a final court decision. While the 8th of September was not that day, it points towards the next, and perhaps most critical, battleground. If the government proceeds with these changes after its consultation, especially if it attempts to apply them retrospectively to people already on a 5-year path, the fight will almost certainly move from the Houses of Parliament to the Royal Courts of Justice. This is not speculation, it is based on powerful legal precedent. In 2008, a landmark case was fought and won by the HSMP Forum, a group representing individuals on the old highly skilled migrant program. The government at the time had tried to retrospectively change the rules for settlement for those already in the country under that scheme. The High Court ruled that this was unlawful and unfair. The court upheld a crucial legal principle known as legitimate expectation. It recognized that migrants who had made life-altering decisions based on the immigration rules in place at the time of their entry had a legitimate expectation that those same rules would apply to their settlement application. The court's decision forced the government to back down. This case from over a decade ago will be the cornerstone of any future legal challenge. So where does this leave us now? The immediate reality is that the 5-year ILR route for both skilled workers and British national overseas visa holders remains in place today. The proposed changes are just that, proposals. They are not yet law. The next crucial step will be the government's formal consultation process. This will be the opportunity for individuals, businesses, and organizations to formally submit their views on the proposed extension to the ILR qualifying period. It will be a critical moment for everyone affected to make their voices heard directly by the policymakers. The question of whether any changes will apply retrospectively to those already on a 5-year route remains the single most contentious issue. The government's silence on this specific point during the debate was deafening. Legal experts suggest that, based on the 2008 precedent, a retrospective change would be highly vulnerable to a successful legal challenge. The path forward is uncertain. The government's consultation could lead to a modification of the proposals. The backlash from the debate, combined with the threat of a costly and embarrassing legal defeat in court, may persuade them to apply any new 10-year rule only to new arrivals. Or, they may decide to press ahead, triggering a legal battle that will once again test the principles of fairness and legitimate expectation in British law. For you, the person watching this, the journey is far from over. This is not a moment for despair, but for vigilance and action. Stay informed through reliable sources. When the government consultation is announced, engage with it. Make your story, your contribution, and your voice heard. Consult with qualified immigration professionals to understand how these potential changes could specifically impact your circumstances. The debate on the 8th of September was not the end of the story. It was the end of the beginning. The fundamental questions about what it means to build a life in modern Britain, and what promises this nation makes to those who choose to do so, are still to be answered. Thank you for watching. Be sure to subscribe for continuing updates on this vital issue. The road ahead is long, but it is one we will walk together.